Did you wish to reserve time for rebuttal?
Yes, Your Honor. Scott Rosen for defendant. If you can reserve 5 minutes for rebuttal, please.
Okay. I have made a note, and I think with that being said, we are ready to begin.
Okay, may it please the court. Your Honors, if you'd let me allow me to start off by laying a proper foundation for this case. If you closely examine the record, you'll discover this is unlike, I believe, any case that this appellate court has heard before. What makes this case unique is the defendant has uncovered fraud from the inception of the attempted origination of the loan and throughout this foreclosure process. Yeah, Your Honor, there are so many issues in this case. I know I can't possibly hit them all within 15 minutes. One of the most significant areas is the fact that the final judgment is completely devoid of the word allonge or certificate of possession.
Mr. Rosen, I want to stop you before you get too far into this because I have a question.
Yes, Your Honor.
That I want to make sure that you answer. On the very first page of the appellee's brief, they say that Campbell purports to raise 8 different issues on appeal, all of which assert that the trial court improperly weighed the testimony and evidence in its role as finder of fact. And to be candid with you, I don't disagree with that statement. So I just want to give you a heads up on that and give you an opportunity to respond specifically to that.
I'm sorry, Your Honor. Could you repeat that? The gist of the argument? I'm sorry. Say
Which part do you want me to repeat?
Which part is it in the brief? The 8 points regarding.
Okay, I'll read it again. This is on the very first page of the appellee's brief.
Okay.
Campbell purports to raise 8 different issues on appeal, all of which assert that the trial court improperly weighed the testimony and evidence in its role as finder of fact. Personally, I tend to agree with that statement. So I want to give you an opportunity to respond specifically to that during your argument today, please.
Okay, thank you, Your Honor. Yeah, Your Honor, there are several issues of fact that clearly weren't even addressed by the court, especially, as I was mentioning, the final judgment is devoid completely of the words allonge or certificate of possession. There are actually 3 allonges.
How is that a legal error?
Yep, allonges, Your Honor, are permanent fixtures to the note. They can't just disappear. There was an original complaint.
No. I think you misunderstand my question. How is it a legal error that the trial court did not reference it?
Yeah, because we believe that the plaintiff is coming to the court with unclean hands. The state court didn't even address the fact that there are 3 allonges. There's one certificate of possession, for example. The same certificate of possession is used for the original complaint and for the amended complaint. The original complaint has different attachments to the note, different allonges, than the amended complaint does. Yet the certificate of possession says that under penalty of perjury, the representative states that the attached is a true and correct copy of the note, with all the attachments, when there's clearly different allonges to the original note and to the amended original complaint and amended complaint. The allonges, of course, Your Honor, are permanent fixtures to the note. They can't just be taken. The first allonge, actually signed by Mr. Wantland, was not even what I refer to as the first allonge, signed by C.A. Wantland of Wantland Realty Corp. It was not even attached to the original complaint, and it was not even attached to the amended complaint. The plaintiff hasn't provided this allonge in the course of their entire case, yet it somehow exists. The defendant obtained it prior to the inception of this case by sending a request for information to Wells Fargo. Wells Fargo provided him with a copy of this allonge. Plaintiff hasn't acknowledged in the original complaint or the amended complaint that this allonge even exists. And of course, according to the UCC and Florida statutes, the first allonge should still be permanently fixed to the alleged original promissory note. It's a permanent fixture. There's a second allonge, Your Honor, it's nonsensical, I call it. It was attached to the original complaint, and but it was not attached to the second complaint. This allonge was actually included in the original twice, but somehow mysteriously and permanently removed from the promissory note contained in the court file. My client had hired experts, forensic document experts from Hindsight Imaging Inc., to scan the note for document, for forgery, for analysis, whether or not it was original. They went to look for this allonge, but it was missing. It was actually taken out of the court file, somehow just disappeared in thin air. The bank's rep, Jessica Reef Jones, testified at the trial that the note, and the note I'm referring to, I'm sorry, I call it the second allonge. This allonge is nonsense in the sense that it was signed by my client as president of the lender, WRC Mortgage Corporation, which of course makes no sense. Originally, my client acknowledged in the deposition that he must have signed an error. There must have been a misprint, and he signed a lot of documents at closing. However, later, of course, when my client discovered fraud, numerous issues regarding Wells Fargo, and that's prevalent throughout this case, he realized that this must have been yet another document that Wells Fargo created and forged his signature on by mistake. At court, Jessica Reef Jones testified the document was removed because it wasn't needed. That's the trial transcript on September 18th at page 361. She testified the allonge was removed because of my experience of doing this particular job and looking at the document and understanding what the document was indicating, that it made absolutely no sense as far as chain of title transfer. It would go to
Let
a conversation.
me just interrupt you just for a
Yes.
second. So is your argument that the trial court erred in not giving sufficient weight to that testimony?
Well, correct, or the trial court erred by not throwing out the case because the plaintiff is committing fraud. There are 3 allonges. They should all be attached to the note. The plaintiff can explain away this one, maybe this was a mistake. They can't just say, we removed the allonge because, obviously it was a mistake. The bank should have an error sheet, a errata sheet that shows any discrepancies in the case. If credit was given for insurance monies, something to that effect. There's no errata sheet showing that allonges were removed or why they were removed.
Mr. Rosen, is what you are asking this court to do is to read the transcript of the proceedings below and reach a different result?
I would ask the court look at all the evidence, Your Honor. I mainly addressed everything in my
Well,
brief.
I'm concerned about what standard of review we are to apply and what authority we have, as you are suggesting, to weigh the evidence. I'm not aware that we get to reweigh the evidence that the trial court considered. As the trial court, the case law says quite regularly, is in a better position to see the witnesses, hear the witnesses, and evaluate their testimony.
Yes,
So
Your
how
Honor.
do we get to the point where you want us to get?
The problem is, Your Honor, is that the trial court ignored a large portion of the evidence that weighed heavily in the defendant's favor. For example,
You say ignored, the other side's going to tell us did not give credibility to. Isn't that what the trial court's task is to do?
Yes, Your Honor, but I don't know how the court cannot give credibility to the plaintiff's own allonges. It was their allonges that they prepared, that they attached to the note. It's not something that the defendant prepared or the defendant relied on. It's something that the plaintiff relied on. Just like with the certificate of possession, Your Honor, the facts are clear that instead of obtaining an updated certificate of possession to match the change in allonge attachments, there was a change in attachments to the note of the allonges between the original complaint and the amended complaint. Yet they used the exact same certificate of possession. My client actually went so far as to take the deposition of Linda Tang, the person who signed the certificate of possession. And she acknowledged that when the second amended complaint was done, she hadn't worked at that company for at least 6 months. She hadn't even worked there anymore. So that's why, Your Honor, we believe the plaintiff is coming forward with unclean hands. The certificate of possession specifically says on its face, paragraph 2, a copy of the note with all allonges, if any, is attached hereto and incorporated by reference as Exhibit A. But it wasn't. There are 3 allonges. And the plaintiff didn't dispute the allonges exist. The plaintiff's representative even said at court that the document made no sense and that it was probably removed, I believe she said, because it didn't make sense, it didn't belong. It should still be attached. It can't just be removed. You can't just remove a permanent fixture to the note. That's one of my big positions, Your Honor, regarding the certificate of possessions and the allonge to note. Also, Your Honor, of course, is the issue.
Well, let me ask you this, counsel. What does the UCC and Florida statutes require if an allonge is not on the note? Does that impact the note's ability to be negotiable? Or what does it do to the note under the statutory code that we've adopted as provisions of the UCC and what the 672 area of Florida statutes?
Yes, Your
So
Honor.
if the allonge is there, does it affect the negotiability of the note? Is it, you're arguing that it makes the absence of the allonge makes the note entirely a fraud?
No, Your Honor, but the fact that it wasn't, that allonges weren't attached is where the fraud comes in. The plaintiff can't pick and choose what documents are strongest in its favor. Just like part of our argument goes to the fact about hindsight imaging doing the forensic document
But
analysis.
even if the plaintiff did, as you argue, the note and the missing allonge was brought to the attention of the trial court, and a fact pattern was given to the trial court to consider. Is that correct?
Yes, Your Honor. Yes, Your Honor. And my point is that the final judgment doesn't even address the issue. It just skips over it as if it didn't exist, as if it's such a minor issue that I'm not even going to mention it. And right, if I can too, move on. The WRC Mortgage Corporation, for example, the originating lender, that corporation didn't even exist. There's an undisputed fact throughout the collection of Campbell's loan documents that WRC Mortgage Corporation was a previously administratively dissolved corporation. There was nothing filed in the complaint, no separate count for reformation of the mortgage, no separate count to modify the note for purpose of getting the correct name, original entity on the note. The court actually specifically denied plaintiff's or tenant's motion for leave to allow the pleadings to be amended to conform the evidence with regard to WRC Mortgage Corporation as the fictitious name of the plaintiff. And we believe, of course, the note mortgage cannot be transferred to an entity that does not exist. It's interesting to note too that Calvin Wantland actually testified. His deposition transcript was read into the record. We did not operate as WRC Mortgage Corporation, nor were we filed with the state of Florida to operate under that name. A corporation, of course, that has been dissolved cannot continue in business. And you cannot, the plaintiff's argument, I realize, is that it was a fictitious name. They were doing business as WRC Mortgage Corporation. You cannot have a fictitious name as a corporation. Corporations cannot be used as fictitious names. My client also, just before the trial, 2 days before the trial, which he did testify to this, he began an investigation of the public records in the state of Florida. He discovered an additional 64 mortgages using the WRC Mortgage Corporation name, spread out over several counties between the years 2005, 2008, which I believe impeaches Calvin Wantland's testimony of it being a mere scrivener's error. My client, unlike most defendants, my client, as soon as he discovered some issues early on, he questioned the validity of the mortgage and note with the Wells Fargo and with the fact that WRC Mortgage Corporation didn't exist. He sent requests to Wells Fargo that were never answered in order to, I actually sent a detailed 50-page verified notice in 2014 demanding Wells Fargo prove the rights to the note according to the UCC. The court heard all this, but they didn't address the defendant's arguments regarding failure plaintiff to reply to the notices by defendant and the effect and consequences of plaintiff responding by actually providing forged or inexplicable allonges. My client had actually hired an attorney. He was about to file a declaratory action against Wells Fargo in order to get to the bottom of things when he was actually served with a foreclosure case. My client also discovered early in his investigation that the endorsement allonge had an image of the signature. I'm sorry, excuse me. My client also hired Hindsight Imaging Inc. in order to do a forensic document examination of the note. They use this advanced technology, hyperspectral imaging and optical coherence tomography, to scan the note to determine that the note being offered to the court as the original is not an original. It's actually a fabrication. Dr. Benjamin Bird was admitted under the Daubert standard as an expert in the field of hyperspectral imaging and OCT. That the trial court heard his testimony, yet found that his conclusions didn't match the evidence. The evidence showed that there was a signature on a piece of paper with a note printed on top of it. That even with a blind eye, without using the advanced technology, you can see the signature in blue ink is underneath the line. What we're saying is that Wells Fargo either lost the original note or more likely destroyed it and digitized, somewhere along the line digitized it. Instead of using a lost note count, they're trying to get past the self-authenticating documentation language of Florida statutes to avoid the hearsay, the admissibility of the note by providing a forged note. Dr. Benjamin Bird actually had 3 conclusions. The signature of my client was underneath the line. It was actually printed first.
I
with the
need to
note
advise you,
printed over.
counsel, you're at 15.
Oh, thank you, Your Honor.
It's still your time. You can keep on using it if you wish.
He also found that Calvin Wallace's signature was also applied to the page first with the note printed over it. And using optical coherence tomography, one can actually determine the chemical composition of the matter on the original documents. He concluded that Linda Tang, the person who signed the other the assignment, that her stamp was composed of ink from a printer instead of ink from an actual stamp. I'll go ahead and defer to in my time now, Your Honor.
Okay, thank you, counsel. 1 second, please, so I can turn off the machine so that next counsel doesn't start at that time. All right, Mr. Morandi, we are ready, sir, for your presentation.
Thank you. May it please the court, Your Honor, Dean Morandi of Carlton Fields on behalf of the Applee Wells Fargo Bank. I think the court pretty much hit the main issue on the head in terms of the substantive issues that the appellant has raised here, in terms of they are all evidentiary issues that the court, as trier of fact, weighed the evidence and determined adversely to Mr. Campbell. And pretty much with that alone, all 8 of the arguments can be rejected. But I'd like to start with 2 issues that allow the court to affirm without even getting into those evidentiary issues. And the first one is the trial court's ruling on unjust enrichment. If you look at the judgment itself, the court plainly ruled that it found in favor for Wells Fargo an unjust enrichment. And for that reason alone, the foreclosure judgment can be affirmed. And if you go back to the initial brief does not challenge that alternative basis to affirm the final judgment. And for that reason alone, the final judgment can be affirmed.
Well, let me
Now-
ask you this with regard
Yes.
to unjust enrichment. Does the final judgment then reflect an amount of damages? Will the unjust enrichment have a secured interest that permits a foreclosure?
Well, that's ultimately what the trial court found. I'm looking at page 5042 of the record. It goes through unjust enrichment, and then the court finds the defendant has presented insufficient evidence to prove that Wells Fargo would be unjustly enriched by a foreclosure judgment. Also says that Wells Fargo has shown the defendant received a benefit that under the circumstances would be inequitable for the defendant to retain without compensating Wells Fargo. Now, I think I understand Your Honor's point to be that unjust enrichment might not allow for the remedy of foreclosure. But my point here is to say that this is the finding of the trial court. It's a basis to affirm the judgment. Whether it's correct or not is not an issue here. It has to be challenged by the appellant, and it has not been here. So for that
Right.
reason, that's a basis to affirm.
The failure then to raise the argument waives the issue for appellate review. It's not preserved. Therefore, this aspect of the judgment is required to stand as a matter of law. Is that the argument? Do I understand?
That is the argument, Your Honor. Yes, correct, Your Honor. The other piece to that argument is that because the issue was not raised in the initial brief, it's deemed waived and it cannot be revived through a reply brief. And I think the court is well familiar with that case law. The reason why I raise it is because in the reply brief, part of it's not completely clear, but part of what it appears Mr. Campbell was maintaining is that it can be revived in the reply brief. And I just wanted to make the point that that's incorrect as a matter of Florida law. Mr. Campbell also attempts to get to the merits by suggesting that an express contract exists, so there can't be unjust enrichment. Well, first of all, again, wasn't raised. We don't get to the merits. Second of all, one of Campbell's arguments throughout this case has been to attempt to disclaim the loan documents. Another issue, he suggests in the reply brief that the final judgment is unclear on this. Well, I would direct the court again to the record on this judgment, and I'm looking at 5042. In the record, it's quite clear in terms of what the trial court is ruling on this issue. And Finally, in the reply brief, I think part of the argument is to suggest that, well, you can look at all my other 8 issues, and from there you can cobble together an argument to oppose unjust enrichment. Well, that's not the way preservation works. It's not the way raising issues on appeal works. The other point there is the issues being raised in the reply brief are separate and apart from the issues raised in the initial brief. So clearly, you couldn't just cobble together an argument against unjust enrichment. So I wanted to raise that point in saying that because the appellant didn't sufficiently challenge an alternative basis to affirm the judgment can be affirmed for that reason as well. There's another reason why the judgment can be affirmed, which is ratification. Campbell ratified the loan documents, and just here, this issue was not addressed by the trial court, but we're making this as a tipsy coachman argument. Any ground that supports the judgment is a basis for affirmance. Was not raised in the initial brief either. We raised it in our answer brief on ratification, suggesting that because Campbell paid on this loan for 4 years, 3 of which was directly to Wells Fargo, he was on reasonable notice because as a sophisticated buyer and a real estate agent, he was on notice as to any issues with regard to the loan documents, and he will be deemed to have ratified those loan documents. And looking at the reply brief, there's absolutely nothing on this issue. The only time you see the words ratification is with regard to the court shouldn't agree with this doctrine because it would send the wrong message, for whatever that means. But that's all there is in the reply brief. We also didn't hear anything on that in counsel's presentation here. So ratification presents yet another basis to affirm the final judgment of foreclosure. Now, I believe either of those 2 issues are dispositive, but I'll briefly mention some of the other issues that were raised. The first issue of which is this hindsight imaging, where the trial court, the argument is apparently that the trial court improperly weighed the evidence and it should have credited the testimony by hindsight imaging. This company that has been around had only been around for 4 years at the time of trial. Their primary division is to analyze gemstones, and they have another division with human tissue analysis. They made 3 findings. And just on its face, those findings seem, I don't want to go so far as to say unbelievable, but definitely to questionability. That there was an actual authentic signature by Stephen Campbell on a piece of paper, and somehow Wells Fargo got a hold of that. And because they didn't have the original note, they used this piece of paper with an original signature on it and created the note around it. Somehow the signature was in just the right place, and that was the conclusion of the hindsight imaging. That's questionable to me. And they made that finding twice with regard to another document that had Watland's signature on it. So on its face, that seems somewhat questionable to me. But either way, let's talk about the other evidence very briefly undermining hindsight's conclusions. He had ignored obvious sources of relevant information, such as that Campbell signed in blue ink, and he testified that the form matches the note that he signed, didn't investigate or seek information from anyone involved at the closing, didn't look at the handwriting pressure, didn't look at the age, storage, or transportation of the documents, several issues there. There's also issues in relation to bias. Hindsight Imaging paid $50,000 for this, but guess what? They haven't been paid a penny because it's contingent upon Mr. Campbell prevailing and getting the house free and clear. I don't know. Their payment was made by a quick claim interest in the property. So at this point, they haven't been paid anything. It's contingent on Mr. Campbell winning. The other issue is Bird testified that he found fraud in nearly every set of documents that the company examined. That's somewhat suspect as well. So again, evidence of bias is also an appropriate basis for the trial court to discount that evidence. And then of course, we have the contrary evidence in the case, which is, as the trial court found, Wells Fargo tracked the original loan documents in its system. The system showed that Wells Fargo had these original documents since before this action was filed. And it also showed that the original loan documents were filed with the clerk since 2015, and they've been maintained with the clerk for that entire period of time. As a result, the trial court was well within its discretion as finder of fact to find that testimony not credible. The other issue we've heard in the briefing and we hear today is that there's 3 allonges. I want to correct that language. There are not 3 allonges. There's one operative allonge. There are 2 other documents that are inoperative documents. Let's talk about the first allonge. And I use that language only out of just to make it easier to understand, because that's what Mr. Campbell has been calling it. It's a document that happened to be in the loan file. It was produced to Mr. Campbell because it was in the loan file, but it was never an operative allonge. It was not attached to the original complaint, not attached to the amended complaint, not attached to the original note filed with the court, and it was not part of Wells Fargo's case in chief for foreclosure. It's just a document. It was not a legally effective allonge. And of course, the trial court was free to reject whatever inference Campbell sought to draw from that document. Second document is, again, not an allonge, but I'll say second allonge, just so the court understands what I'm referencing in relation to Mr. Campbell's argument. And Mr. Rosen himself correctly noted that this is a nonsensical document. It is a document signed by Mr. Campbell on behalf of WC Mortgage. Obviously, that's not an appropriate document. Obviously, that was a mistake. Testified to that it was a mistake. It is plainly not an operative allonge. It is just a piece of paper with no legal effect to it whatsoever. And then finally, what's been called the third allonge, that is the actual allonge in this case. That is what was attached to the initial complaint. That is what was attached to the amended complaint. And that is what is, of course, attached to the original note that is in the court file. And that was the document that Wells Fargo proceeded to trial on. And at absolute best, there is a question of fact here that the trial court was well within its discretion to find in favor of Wells Fargo on. We also heard some issues with regard to the certificate of possession of original note. And what I just explained with regard to that there being only one allonge goes into the certificate of possession argument. The argument here is that, well, you had an original, your initial complaint had the note, but it also had that piece of paper that Mr. Campbell signed on WRC on behalf of WC Mortgage, which is by all accounts nonsensical, but the amended complaint doesn't have that document. Well, the testimony is that that document is not any kind of legally enforceable document. It's not anything. It's not an allonge. It's just a piece of paper that has no impact on the enforceability of the note. So it was removed and it does not appear with the amended complaint. For that reason, there's absolutely no reason to go get a new certificate of possession of original note. Nothing has changed with regard to the operative documents. And that's pretty much the end of that argument. That's really all there is to it. And as you'll see with a lot of these arguments, they build on, presupposing that there's fraud, and that's why we get up to 8 issues. Happy to address the issue with regard to the mortgage being properly pled as collateral for the note, but we didn't have any argument by Mr. Rosen on this, so I won't go into that unless the court has any questions. Okay. The fact that the word corporation appears on the allonge, that's supposed to be an argument to say that the note itself is unenforceable. Well, we have testimony by WCR Mortgage's president, Calvin Watland, testifying that the word corporation was there as a Scrivener's error. In other words, it wasn't supposed to be there. He testified to that effect, and for that reason, it doesn't impact the enforceability of the note. It's a Scrivener's error. It doesn't need to be changed. It's something that it's plain that the proper party to the note is Watland Realty Corporation doing business as WRC Mortgage. Now, it says WRC Mortgage Corporation instead of just WRC Mortgage. Well, we have the president of the corporation saying that the word corporation shouldn't be there. Yes, Mortgage Corporation was administratively dissolved. It was something that existed at one time, but it wasn't here. That wasn't the proper party to the note here. It was nothing more than a scrivener's error. And again, the trial court was well within its discretion to agree with that testimony and find in Wells Fargo's favor on that point. That is, for the most part, all of the arguments that have been raised here today. There's a couple more in the brief. We can stand on our brief to the extent the court has any additional questions. If the court has no questions, I will wrap up and say that I think we have numerous bases to affirm the final judgment of foreclosure here, and that is the relief we would request.
Thank you, counsel. I don't see any questions, so let me address the time clock here and change it over so that it works properly for everyone. Mr. Rosen, you have 4 1/4 minutes remaining.
Yes, Your Honor. Thank you. If you can remind me when I have 1 minute left, Your Honor, if you don't mind.
I'll do my best, sir.
Your Honor, the problem I have, if the court allows a mortgage foreclosure based on unjust enrichment and ratification based on the fact that you made payments, therefore you ratify the mortgage, all mortgages would be very quickly taken care of. They can be taken care of in summary judgment. We don't need to go through conditions precedent. We don't need to go through standing. The plaintiff only has to show that the homeowner received monies and the homeowner made a few payments. Therefore, we win. This entire 4-day trial could have been avoided if we just came to that conclusion right away. Now, the plaintiff chose not to authenticate the signatures. They chose not to have their own expert testify. All they did was attack our experts. We're not saying that Mr. Campbell didn't sign the original note. Of course, he signed the original note. What we're saying is the plaintiff lost or destroyed the original note. Instead of filing, which should have been proper, a lost note count, they recreated the note and used it fraudulently to overcome the presumption of an authentic note. Therefore, Mr. Bird testified that he's a scientist. He looks at objective facts. He testified the fact that there's no need for me to talk to Mr. Campbell. Ask Mr. Campbell, he signed the note. He's a scientist, looks at the objective facts. He used scientific principles that are accepted in the community using optical coherence tomography and hyperspectral imaging, and he reached his conclusions. So a lot of the points raised by opposing counsel, I don't believe are genuine. If you look at
Mr. Rosen, I want to
Yes.
make sure I understand some of the facts here.
Yes, sir.
You have argued that your client did in fact sign a note and a mortgage encumbering the subject real property. Is that correct?
Yes, Your Honor.
And did your client deny the breach by the failure to make payments?
My client withheld payments with dishonor. He specifically sent a certified letter to Wells Fargo explaining his concerns, to which Wells Fargo did not respond to him.
I understand, having read the news media about what Wells Fargo has done in other areas of its business, and I'm certainly not challenging your client's suspicions. My concern is here, as I understand it, we're basically admitting all the allegations except for the formality of having the original note or a lost note claim. Is that what you're saying, is that these are the technical obstructions to affirmance? Is that correct?
Yes, Your Honor. No one
Okay,
should
I
come.
just want to make sure I got everything philosophically lined up.
Yes, I believe so. Good. No one should be able to come to this court with fake, fraudulent forged documents. The state court should have been very upset after hearing testimony from our experts regarding the authenticity of the note. I'm sorry, give me 1 second. The Doe case. The Doe case cited by the plaintiff, it's incorrect. It doesn't apply in this case because the Doe case stands for the proposition that by failing to challenge or address the alternate ground supporting the final judgment foreclosure, they say that the appeal cannot succeed. In the Doe case, the court stated that in the initial brief, the appellant completely ignored the ruling. Although in its answer brief, she argues at some length in its position, she chose not to file a reply brief addressing that argument. Therefore, of course, as I repeatedly stated in the reply brief, we did address that in the reply brief. Therefore, we don't think we waived any rights to argue unjust enrichment. Unlike Doe, the reply brief specifically addresses the issue being filed in this case. Also, unjust enrichment, Your Honors, is actually an equitable remedy. It should fail upon a showing that an express contract exists. Unjust enrichment should be an alternate to.
You have 1 minute
finding
remaining.
that no contract exists. Thank you, Your Honor. Also, the trial court's order doesn't actually state unjust enrichment, only that Wells Fargo has shown that the defendant received a benefit that under the circumstances would be inequitable for the defendant to retain without compensating Wells Fargo. The reply brief cites over and over and over all the different circumstances of this case, which I defer to as to why the plaintiff should be successful in this action. Your Honor, collectively, the appellee fabricated evidence, altered evidence, removed an allonge from the court file, used the same certificate of possession twice to verify different allonges, offered a forged recreation as the original note, possesses a mortgage that failed to create a security interest in the real property. All this is covered, of course, in my brief. They allege Scrivener's error using a fictitious name for corporation, when public records show an additional 64 mortgages using the same name, but there was no Scrivener's error. Yeah, I asked the court, please review the briefs in detail because I know there's a lot more that we can't argue in these few minutes, but I believe that our position is clear and that the plaintiff should not be able to prevail on foreclosure.
Thank you,
Your Honor.
counsel. Thank you both for your presentation. Let me clear the clock so I don't start the next case improperly. Stay well. We'll see you next time.
Thank you, Your Honors. I appreciate it. Have a good day. Thank you.
Thank you. The next matter to be brought over is Central